People of the State of New York versus James McIntosh. Good afternoon, counsel.
Good afternoon. May it please the court, James Hobbs of the Monroe County Public Defender's Office, on behalf of James McIntosh. I would reserve 2 minutes for rebuttal.
Of course.
The trial court's error in refusing to instruct on either of the two requested forms of non-intentional homicide calls for reversal in this case.
So let's start with the very basic threshold question. What is your reasonable view that you're urging of the evidence here that would justify any lesser included being charged?
Well, the most important part of it is that Mr. McIntosh testified in detail that he acted solely with the intent, and thrusting the knife forward solely with the intent to scare off and back away his drunk and belligerent roommate who was charging forward at him, and that he did not foresee the possibility that this would cause a serious injury or lead to his death. In fact, his testimony was that the roommate continued to charge forward into the knife when he thought that the thrusting motion would cause him to back off and be scared away. So that testimony clearly makes this a reckless and brings it act and brings
Wasn't
it within.
justification charged in this case?
Justification was charged.
And that had to be rejected, right, as part of convicting him on the greater offenses.
That's correct. And I believe what the...
So I'm still having trouble understanding the reasonable view given that fact.
If they rejected justification, then they found that his action was not objectively reasonable. That's the most you can infer from the fact that they've rejected justification, that he didn't make out a case that was called for, and that it was an appropriate way of acting. And that's completely consistent with it being reckless and being negligent.
Counsel, is the court bound to accept the defendant's testimony that he was unaware of the risk that...
For the purpose of the standard of review for whether or not to charge, or the legal standard for whether or not to charge a lesser included offense is and effectively you are bound by it, that you have to take the evidence in the light most favorable to the defense.
And is the court entitled to look at the evidence of the nature of the wound?
Sure. But in this case, the medical examiner's testimony was quite consistent with his testimony. She agreed that the force could have been supplied by the victim coming forward into the knife, and that his theory of how the angle of the wound was consistent, she couldn't rule that out. So I think there's nothing
What about the argument that that this was error, but the error was harmless because conviction of the top count would preclude that? You're arguing intent. Recklessness is so non-homicidal intent. That's what you're arguing. They should have charged that. And I think the case is Betcher, I'm not sure how to say it, says that if you're convicted on the top count, then you've established homicidal intent, and that question is disposed of. So while it may have been error, it was harmless error.
Correct. I've outlined in the brief there are a couple of precedents from this court that don't apply the Bocher rule in circumstances that are quite similar to this. And those are, the key ones are Green and Lee. And there have been attempts to distinguish Green, but they don't get to the heart of what's parallel between Green and this case.
Green was, just looking at my notes here, it was assault one. It wasn't, and there the court held it wasn't a lesser included offense of attempted manslaughter two, right?
I believe the charges were attempted murder in the second degree, assault in the first degree. So the jury was presented with, intent, a crime where they would have to find intent to kill, and a crime where they would have to find intent to...
Important point is you have three crimes.
Right.
You have the murder crime, right, on top, the homicidal crime, then you have assault one, and then attempted assault two. It doesn't, lesser included offense that was held doesn't apply to attempted assault two, right?
I believe that was assault two, was the crime. Yeah, not attempted.
Oh, okay, not
That was what they were not
manslaughter
charged
to
with.
assaulted. All right. So the elements weren't the same. They weren't in the same line. The CPL doesn't set them out in the same fashion.
But the elements do line up, the factual issues and the elements do line up with this case, if you look at the mens rea. The jury found intent to kill and intent to cause serious physical injury, which is precisely what they found in Green and precisely what they found here. And the court said, that doesn't rule out that if they'd been given recklessness, they would have abandoned both of those findings of intent and moved to recklessness. And that's because recklessness is a different form of culpability.
What impact, if any, does the failure of the defendant to object to the trial court's error in not charging the murder and the manslaughter in the alternative?
I don't think that it has an effect here. My argument does not, I have made an argument that because you have both verdicts, the Bocher rule shouldn't apply. But I have a second argument, which is also that even if they'd been given them in the alternative and the jury had, if we can hypothetically assume the jury would have stopped at murder, the rule, Bocher rule still should not apply here. And that's, there's a precedent for that in Lee and a number of Second and First Department cases that have followed Lee. And that is just simply because the factual issues, the charges given to the jury and the charges don't line up with what was the key factual issue in the case. They weren't given a choice that reflects what the defendant's testimony was, but that his crime was merely reckless and therefore mitigated form of culpability. So to come back around to your question, I would say that I don't think it has any impact, but it would only go to that first argument if it did.
I thought Lee just dismissed the lower count. Am I missing something in Lee? I thought the remedy in our Lee case was they dismissed the lower count of possession.
I believe Lee reversed for a new trial where they would have.
What's the
jury would
site?
have the
What's your Lee site?
The site for Lee is 35 New York 2nd, 826.
Okay.
And there, the crimes lined up exactly. It was murder in the second degree, manslaughter in the first degree were both given to the jury. And the court said, look, there was evidence that the defendant was intoxicated, and the circumstances are very strange here.
Yeah, but there, the intoxication, the argument was that there was no capability of forming intent. Was there an intoxication charge requested or given
There was
here
not
at
an
all?
intoxication charge here.
Okay, so-
The people presented evidence that Mr. McIntosh was intoxicated. One of the witnesses, Terry Snyder, testified that he was drunk, he was slurring his speech. You could also, and the defense also presented evidence that he was drinking all day long. That evidence of intoxication is at A590 in the people's case.
but
So the
is
jury
there-
certainly could have credited that.
Is there any view of the evidence that he was so intoxicated that he could not form an intent?
I don't, that was not an argument made, and I don't think that's the case, but you don't have to be so drunk to not be capable of forming an intent. I mean, he said, I had the intent to back him off.
But that goes to your argument that the jury should have been provided with an opportunity to find a non-intentional crime.
Right.
And you rely on Lee, but Lee was a circumstance where there was evidence that there was an inability to form any kind of intent.
It's still the same basic point that Bocher does not apply when you have this disputed factual issue. And you can't just look at verdict on the top count. Therefore, the more remote lesser is not available.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. May it please the Court. Scott Miles on behalf of the people. The question this Court has to decide is whether or not Bocher means what it says. Does the conviction for the top count preclude any relief on the failure to read lesser, more remote, lesser included counts? In this case, the defendant was convicted of the top count, murder in the second degree. That conviction necessarily precludes any argument that the jury might have found guilt on a reckless mens rea. Reckless and intent are mutually incompatible. they cannot both happen. So the jury in this case returned a verdict of guilty of murder in the second degree. Now, due to an error on the part of the court.
Right, so if he didn't, if the trial judge had charged the must acquit language, we wouldn't even be here.
Exactly. It was that error that, as far as I can tell, has never occurred in the 112 years since this rule was outlined in People v. Granger, and is unlikely to ever occur again. Were it not for that very unusual circumstance, we would not be here. So the only question that this court is really presented with is, does that second error by the court remove this case from the line of cases under People v. Granger for that exception, which was outlined again in People v. Botcher, that the failure to read the more remote lesser included is necessarily harmless error when there is a conviction of the top count. So the dissenting opinion at the appellate division was of the opinion that essentially that the conviction for the manslaughter in the first degree, because of the decisions in cases like People v. Green, means that it's not harmless error. I believe that's a misreading of People v. Green. The rule is, as was discussed in Botcher, in dicta, and again in Green, that if there is a conviction for the top lesser included count, in this case manslaughter in the first degree.
Let me ask this. If the court had charged in the alternative,
Yes.
then would the defendant have been entitled to a manslaughter charge as a lesser included offense?
Well, the question is not would he have been entitled to it. The question is, would the failure to read it be necessarily harmless error?
Well, the reason I ask is because then the jury would have had it in front of them to consider. And this way
Yes.
they didn't have it to consider. Usually what happens is they convict on the top and they don't address the other ones. But here, they convicted on two different lines.
Correct, because of that failure to read the alternative.
And that failure meant that they did not have in front of them the manslaughter 2 charge. And that's the way I understand the dissent's argument. Am I incorrect about that? Tell me how you read it.
I read the dissent's argument more as saying that because there was a finding of guilt as to the lesser included, which was read, manslaughter in the first degree, that because of the dicta in Botcher and the decision in Green, which says that it is not harmless error when there is a conviction for the top lesser included, which is read, that it's not harmless error. However, all those cases were discussing that the conviction of the top lesser included as an assumption that there was an acquittal on the top count charge.
Right, and that's not what you have here.
That is not what we have here. So again, had the jury been read the correct instructions, they never would have gotten to man 1. They certainly never would have gotten to man 2, even if it had been read, which is why this case still falls squarely within the Granger exceptions.
Well, is there an argument that had the jury been given the manslaughter 2 charge, it would have had something different in kind in front of it, in that in looking at the 2 charges it did have in front of it, what it was being asked is, how serious an injury did the defendant intend to inflict? And the man 2 charge would have asked a different question, not about the seriousness of the injury, but about whether there was an intent to injure at all. And so that sort of takes you out of the Botcher-Granger line, which, you know, when you're talking about how much money in a larceny case, that seems somewhat different in kind to what's going on here.
It is different in the sense that, again, you're correct, it is a separate mens rea. And that question of whether or not cases with a different mens rea than the top count charged and the top lesser included charged should be an exception to the Granger rule. The appellant in this case is asking for you to carve out an exception to the Granger exception. So an exception to the Granger rule when it is a different mens rea. That is, I believe, an extension that has not specifically been disavowed by this court, but it has been disavowed by this court in the sense that the defense is asking you to encourage jury nullification by another name. The jury in this case specifically found the defendant intended to cause the death of the victim and did in fact cause the death of the victim.
But possibly because it didn't know, it had the option to say, you know what, he caused the death of the victim. He did it really criminally negligently, but maybe not intentionally. So their choices were acquit or say he intended to do it, and it was closer to he intended to do it than he had no responsibility.
Exactly, Your Honor. They had the choice to acquit if they found that he did not intend to cause the death. By carving out the exception that the appellant urges this court to carve out, again, we would be encouraging juries to reach compromise verdicts, which this court has repeatedly found.
But haven't we also said that the other problem we're trying to avoid with submitting the lesser included is a jury feeling that there is some culpability and they don't want to acquit completely? And this is where you're stuck in this case.
Which is exactly why the Botcher and Granger rule exists in the first place, because in this case, as in the entire Granger line of cases, the jury was given a choice between levels of culpability. They were given a choice between murder in the second degree and manslaughter in the first degree. They found him guilty.
But if the choice is more as to what Judge Wilson is suggesting, then their choice is acquit or find guilty, and they're not. And we're back to the problem that we're trying to address by not letting the jury really be stuck with either we have to let this person completely go or we've got to find them guilty of something.
Again, I believe the Granger rule as it stands is the appropriate balance between those two choices. The jury in this case was not given just murder in the second degree or acquittal. They were given murder in the second degree, manslaughter in the first degree, and as Granger and Botcher and the entire line of cases has said, the finding of guilt on the top count in that situation precludes.
Does your office concede that this was the error on the court's part, but that it was harmless, or are you saying it was not error?
We do make the argument that it was not error. I understand that it's a very low threshold for whether or not they should have been read manslaughter in the second degree. It's the view most favorable to the defendant. The defendant did testify on his own behalf. However, we do make the argument, and I believe it is a valid argument that the defendant did not make out a case for reckless mens rea in this case. The defendant, if you read his testimony and you read the defense's case really in its entirety, was trying to have his cake and eat it too throughout the entire case. He was going for a justification defense, which given the facts was, I believe, a much stronger defense than a reckless mens rea. And so his testimony was going back and forth. He was saying, well, I intended to stab him, but I didn't really intend to stab him. I just wanted to get him.
Well, no, I mean, we've recognized that you can have an intent to stab somebody, but not intend the level of injury necessary to meet the higher crimes, such as serious physical injury versus physical injury, or certainly death. Right, so. That's
certainly true, Your Honor, but I don't believe the defendant's testimony in this case, and even a reasonable view, would lead one to us to see recklessness instead of intent, given the fact that he was stabbing somebody in the chest with a knife.
So the point being that there's different levels of intentional crime.
Yes.
Based on his testimony, but not negligence or
recklessness.
Reckless.
Correct. But
there is a view of the evidence that it's the victim who propels himself into the knife.
That was what the defense argued, certainly, and the medical testimony did not preclude that.
Correct.
As a possibility. However, the people are not conceding that it was error in this case. However, I do believe the much stronger argument is that even if it was error, that Granger, Botcher, the entire line of cases says that it is harmless error.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honors. The problem with the Botcher and the Granger rules is they don't attend to the way in which the charges line up with the factual issues in the case. And so not every set of hierarchy of greater and lesser included offenses falls in a neat line. Some of them have elements that differ in certain ways, and that's the case here. We have two intent crimes and reckless and negligence crimes, which are different in kind. And those crimes corresponded to what Mr. McIntosh testified and what the other defense evidence supported. The jury was given a choice that did not line up with his testimony. He never testified that he had the intent to cause serious physical injury or the intent to commit murder. His intent brought it squarely within recklessness. The jury did, to find man one, the jury would have still had to disregard his evidence. Essentially, his testimony had the effect of, I took a risky act, a risky defensive act.
But if the
I
jury
didn't mean-
thought that he didn't mean to cause death, certainly, they had this available,
It's still,
they're included, right?
that's a theoretical possibility, but they still would have had to ignore exactly what he said and discredit what he was saying, which is even that I didn't mean to stab him, I didn't mean to cause serious physical injury. I just meant to poke him and for him to be scared and back off. And so, under the law and under common sense, when someone says, yeah, I did something reckless, or I did something dangerous, but I didn't mean for this bad outcome to happen, no one thinks that should be wholly exonerating. And this jury reasonably did not think it was wholly exonerating. But they weren't given the choice to give it the weight that the law allows it. The law is that this should be a lower form of culpability. And the jury had no choice to do that, but instead just to acquit him. And in People versus Moran, Cardozo, this court has said the jury should not be left that choice between conviction of murder and acquittal.
Thank you, counsel.
Thank you.